It's a complicated piece of law. We've never done anything like this in the history of the UK, and probably it hasn't happened anywhere else in the world. If you look for the word asbestos in what I'm going to call the REUL bill for short, you won't find it mentioned because it's what's called a Framework Act of Parliament. And that's what makes it very tricky. What it aims to do is to take away any European historic influence over British law. So it's a clean-up of any reference to European law. Our current asbestos regulations were passed during the time that we were members of the European Union, and the European Union had competence over all matters health and safety. So when they put together the REUL bill, they listed, and you can find the list on the REUL Navigator, about 4,000 laws that had been influenced by Europe. And one of those laws was the regulations that govern all of our management of asbestos, which have been recently reviewed by Health and Safety Executive and also subject to scrutiny by Parliament. However, the operation of the bill would mean that the relevant minister, the Minister for Work and Pensions, would need to either restate, so that's repeat, the regulations under the power of this bill, the REUL bill, or could reformulate it, those in a different way, subject to a restriction. And the restriction in clause 16 is the thing that really worries us, which basically means that you cannot increase the regulatory burden if you restate a European law. Now, increasing regulatory burden basically means it can't cost more and it can't be more administratively inconvenient to do it. So you can never have a new asbestos regulation that costed industry more than it costs now, that put more of a burden on business or on the government than it does now. So that's the, if you like, that means that the current asbestos regulations as they are, even if they were restated, could never, under the REUL bill, be stated to be anything higher. Now, one of the things that hasn't been noticed in the parliamentary debates explicitly, but I've confirmed with legal authorities within the House of Lords, is that the power to legislate in asbestos moves by virtue of the REUL bill from the Health and Safety at Work Act to the REUL bill, while clause 16 is still in there. So what this basically means in practical terms is even if at the end of the year, the existing asbestos regulations are republished word for word, they will be republished under the authority of the REUL bill, which means in future, there will never be the possibility of those regulations being extended or expanded to increase the regulatory burden. The authority for them would derive from the REUL bill, not from the Health and Safety at Work Act. That's quite a significant thing. That if you look at the notion of not increasing the cost, it means in 20 years' time, the value of money will drop by about 50%. So we'll have an expectation that it will cost half what it currently costs to implement this bill. Now, there's not an intended consequence. I absolutely, genuinely believe that nobody in Whitehall wishes to do anything to limit our capacity in the future to regulate asbestos. It's the unintended consequence of an overly complex piece of legislation. And there's a very simple solution. We already have the sovereign power since we left Europe to use the Health and Safety at Work Act, the powers under Section 15, to just reissue the regulations. They've just been reviewed, they've been through Parliament, they can have any taint of Europe removed. They could just be reissued under Section 15 and taken off the list of the REUL Navigator. It's as simple as that. But the unintended consequence of reissuing, restating, or revamping the regulations but under the REUL bill may live with us for decades, may live with us as long as we have to live with asbestos. People reading the news might think that this is a past issue, that REUL bills, there's a U-turn. My understanding is that the government is committed to continue with the REUL bill. They may not be ending the effect of a number of the regulations, perhaps up to 3,000 regulations by the end of the year, which was the target, but that doesn't mean that they are dropping that. We urgently need clause 16 of the bill as currently stated to either explicitly remove the effect of the bill where there is an existing statutory power to make regulations, or we need to remove the control of asbestos regulations from the list of regulations to be restated and simply deal with them under the perfectly adequate competence of Section 15 of the Health and Safety at Work Act. If this does not happen, there will be companies who will be going to court in the next 20 years saying that there is not a lawful power on HSE to change, modify, or improve, or even maintain the current levels of protection of asbestos. It's a complex legal issue. It will be played out in the courts. It will cost millions in the country's resources, and it will cost lives.